Welcome back to Deb's True Crime Notebook, where we read the documents for you so you don't have to. We have 24 pages to read to you from Andrew Baldwin. Grab your coffee, folks. It's going to be a long morning. Let's get into it. Richard Allen's verified reply memorandum to State of Indiana's response to preserve and produce and request for sanctions. Comes now Richard Allen by counsel and files this reply to the State of Indiana's February 28, 2025 response to Allen's motion to preserve and produce and all request sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. The prosecution's response brief provided proof that the state of Indiana failed to turn exculpatory evidence over to the defense. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though in February 13, 2025 email he denied processing such letters. McClellan also has no explanation to as why a letter from Davis from October 15, 2024 is missing and cannot be found. Instead, the prosecution spends the majority of his response denigrating defense counsel. Prosecutor McClellan is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. The law is the arbiter. Exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. State v. Durrett, 923 NE 2D 449453, Indiana Court Appellate, 2010. Carroll County Local Rule 18b2 also requires McClellan to turn over exculpatory evidence. Based upon his February 28, 2025 filing, we know that the state of Indiana had certain letters in its possession in October 2024, but failed to turn those letters over to the defense until February 28, 2025. The prosecution only produced those letters after the defense sought those letters, being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. This behavior of the state is consistent with a pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of this case, as will be recounted later in this memorandum. A pattern of withholding exculpatory evidence may lead to a reveal and new trial. Pruitt v. State, 819 NE2D 393, Indiana Court Appellate, 2004. This case illustrates what happens when the state engages in a pattern of withholding exculpatory and material evidence from the defendant prior to trial. In Pruitt, the Court of Appeals reversed the conviction when, soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. Defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13, 2017, the victims were abducted, taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14, 2017, after the search parties had left the area, were ultimately transported to the location where they were found on February 14, 2017. Further, the defense's theory was that evidence strongly supported the multiple people were involved in the abduction and murder of the victims. The defense theories were detailed in the defense's opening statement and throughout trial or in offers to prove from August 1, 2024, state's theory. The state's theory was that in some order the following events occurred. The killer acting alone after running or briskly walking across the bridge to catch up to the girls, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video, walking casually and not panting like a 45-year-old who had run across the bridge, then abducted the two victims, slid down a steep hill with those victims, then in a panic after observing a van, corralled those victims across an active creek while holding a gun, and then both victims somehow were undressed, but the younger victim was later redressed in the pants, bra, and sweatshirt of the older victim, and the lone panic killer murdered one victim and then murdered the other victim without anyone hearing any screams in spite of sound traveling very well throughout the area all the way to the bridge. Then the lone panic killer moved the older victim from one area to another area next to a tree without any drag marks, indicating that he carried her from one place to another. All that activity, according to the state's theory, occurred in a 19-minute time frame between 2:13 p.m. and 2:32 p.m., when the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the murders, the state's theory was that this killer panicked, then took time to place sticks on top of the victim's body in a particular pattern as depicted in photos admitted at trial, and then, in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery before this panicked killer chose to walk westbound towards his vehicle on 300 North in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road after having killed the victims an hour and a half earlier. The state's theory was not the multiple women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13, 2017. Ricky Davis' letters provide exculpatory information that supports the defense theory and negates the state's theory, and also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence to be admitted into evidence. In Davis's letters that the state of Indiana did not turn over to the defense before or during the trial, Ricky Davis stated that Kegan Kline, a key suspect in the case, confessed to the murders. A key suspect confessing to the murders is exculpatory evidence, as it tends to establish a criminal defendant's innocence. ID at a minimum, Carroll County local rule required McClellan to immediately turn those letters over to the defense. Even if he, McClellan, believed that those letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Kline and Logan, when the police or prosecutor conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. Now let's pause here and let's read the footnotes at the bottom of the past page. Okay, so this is the footnote at the bottom of the last page that we read. There are several footnotes throughout, so we'll be pausing to take a look at those as we read the document. Carroll County Local Rule 18b2. Additionally, McClellan's claim that he was not obligated to turn over the letters because of Davis's claim that Richard Allen was involved is not a judgment call for McClellan to make. Richard Allen was at home on the evening of February 13, 2017, and the morning of February 14, 2017, according to Davis's letters. Kline indicated that Allen was with them during that night and morning, assisting in the murders. It is McClellan's obligation to turn over exculpatory evidence to the defense and let the defense determine how to proceed. Okay, and now back to the document. So the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather in its absence he received a fair trial understood as a verdict worthy of confidence. Kiles versus Whitley, 514 U.S. 419, 434, U.S. Supreme Court, 1995. The jury in Richard Allen's case was out for nearly 4 days as a very lengthy deliberation period. In this case, Kegan Kline's confession to the murders and also Kline's claim that Ron Logan was involved are clearly exculpatory statements. These were the two most likely suspects during the investigation. If it could be shown that they knew each other, that would be significant fact for the court to consider when determining matters for the third-party suspect defense and also for a jury to consider. The fact that Kline also implicated Allen would not have been of a concern of the defense, as the defense knows that Allen had no linkage to either Kline or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and the morning of February 14th, when Kline is claiming Allen was with Logan and Kline committing the crimes. Had the defense known of the information contained in the Ricky Davis letters, it would have renewed its motion from third-party suspect defense regarding Kline and Allen or Logan, and would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Kline. The defense could have argued that Kegan Kline, knew details of the crime that no one else knew, and further that he, Kline, was protecting an unknown party by claiming that Allen was the third party after Allen's arrest. The defense could do none of that, as well as any other number of legal, strategic, procedural maneuvering if the defense, was in the dark about the contents in the letters while the prosecution was fully aware of that information. The details that Klein provided to Davis add to the exculpatory value of those letters. On page 4 of one of the letters, Davis claims that Klein detailed the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore, that their bodies were staged. These are facts consistent with the defense theory and facts that oppose the state's theory. Furthermore, in the letter, Davis claims that Kegan Klein detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time and purchased exotic fish after having asked a relative to assist him, Ron Logan, in creating an alibi. These are all facts that Ricky Davis would not know, but the killer would know. All those facts tend to establish Richard Allen's innocence, ID. In the second letter, Davis claims that back in 2018, Davis, reported that the victims' throats were sliced. This is something that only the killer would know, especially when the details of the murders were not known at that time. He also stated that he reported that the girls were hidden in a barn and also driven around at the same point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution theory. On page 3 of that letter, Ricky recorded that Kegan Klein told him that the scene was staged and furthermore mentioned to the girls could not be moved because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory. In his February 12, 2025 interview at Newcastle Prison, Ricky Davis provided further details that Davis, claimed that believed that he also provided the prosecution concerning details that Kegan Klein stated to Davis. In that interview, for example, Ricky Davis claimed that Kegan Klein stated that the girls were handcuffed to each other. After the meeting, defense counsel O.J. Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos that determined whether there were any indicators of victims' wrists that would support this new information that the victims were handcuffed to one another. The admitted non-expert eyeballs of the attorneys and investigator observed straight lines on the left hand of the wrist of both girls, which, if true, can indicate that one victim walked immediately behind the other with each of their left hands handcuffed to each other so that they could not easily run away. If the defense had received these letters, it could have learned these facts from Davis during a deposition. If they weren't contained in the letters and then had experts view the same photos to determine whether the photos were indicative of girls being handcuffed. Had the defense known of Kegan Klein's statement to Ricky Davis, it could have brought forth Kegan Klein and Ricky Davis in for a deposition after hours of during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Kegan Klein finally admitted that Richard Allen had nothing to do with the crimes, as Ricky Davis stated to counsel during a jail interview on February 12, 2025, and also to show that Kegan Klein's claim about the activities of the third person involved with him, Klein and Logan, was inconsistent with Richard Allen's whereabouts the night of February 13th and morning of February 14th. The defense likely would have called upon Kathy Allen to show that Richard Allen was at home during the time frame and not with Logan and Kegan Klein. Additionally, the defense could have asked the Department of Corrections to provide video from the very pod where Ricky Davis and Kegan Klein were housed to determine whether Klein and Davis were frequently talking with one another, as Klein has apparently stated in State's Exhibit 4 that Klein has only talked to Davis maybe 2 times. If the video shows that Davis and Klein talked to each other well beyond 2 times, then it could be determined that Klein was lying. Whereas if the video shows that Davis only talked to Klein 2 times, then it could show that Davis was lying. Either way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McClelland's claim that he did not turn over the Davis letters because he, McClelland, made his own determination that the letters were not, in fact, exculpatory, denied Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and to determine what to do, if anything, concerning the contents of those letters. In his February 28, 2025 response, McClelland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McClelland via email before filing his motion. On February 12, 2025, Baldwin had emailed McClelland asking for Ricky Davis letters. On February 13, 2024, or 2025 at 2:41 p.m., McClelland responded as follows. The information that we have concerning Ricky Davis was forwarded to you as part of a discovery. You had every opportunity to call Mr. Davis at trial or at the hearing of the third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out in regards to those motions. Before filing any motions, Attorney Baldwin made one more attempt to simply obtain the letters. The defense responded at 3:54 p.m. on February 13, 2025, by asking McClelland whether he was admitting or denying that he, McClelland, had received letters from Ricky Davis in the month leading up to the 2024 trial. McClelland could have quickly answered the question and then provided the letters to the defense and perhaps avoided any more filings. McClelland also could have asked Baldwin to hold off on filing anything while he, McClelland, gathered the letters to turn them over to the defense. Instead, McClelland chose to ignore the defense's request, prompting the defense to file its February 14, 2025 motion to preserve and produce the Ricky Davis letter. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Also, note that in this February 13th email response, McClelland claimed to have provided the defense all the Ricky Davis letters during discovery. This was simply an untrue and misleading statement typed on his computer and sent to the defense by McClelland. Through his February 28, 2025 filing, the court learned that McClelland actually was in possession of these letters on February 13, 2025, which contradicted McClelland's representation to the defense that everything had been turned over. McClelland chose to intentionally mislead defense counsel about McClelland's possession of those letters. McClelland was getting called out by the defense once again, and once again he was ultimately forced to turn over the letters, perhaps out of fear that the defense would eventually gather DOC records that would then expose McClelland's misrepresentation. McClelland's misrepresentation has yet to be explained by McClelland to his court or anyone else. Are the letters McClelland finally provided the defense truly the only letters? Once again, we have footnotes here at the bottom of the page. Let's take a look at those. Footnote. Once again is referred to the other times that McClelland was forced to turn over items after being called out by the defense, as detailed in the next section of this memo. 3. Allen and the defense are not conceded that the DOC records that McClelland admitted as exhibits are proof positive that other letters don't exist. The defense has no idea how records are kept or how accurate those records might be. The defense is also not sure McClelland was so quickly able to access those records from Newcastle. As detailed above, McClelland's response to the motion to correct errors in which McClelland provides details found nowhere in Ricky Davis' letter provides a compelling argument for the belief that either one, other letters exist or video exists that has not been turned over. Moving on to the document. Are the letters McClelland finally provided to the defense truly the only letters and or videos in his possession? McClelland's recent response to the defense motion to correct error provides troubling statements that cast doubt on McClelland's claims that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defense motion to correct errors in an apparent attempt to discredit Ricky Davis, McClellan claims that McClellan had information that Ricky Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious because the prosecution has failed to produce any document or videotape in which Ricky Davis makes such a claim. The defense has found nothing. This leads to serious questions of where did McClellan learn of this information? The defense is left with one or two possibilities. One, McClellan has additional Ricky Davis letters, reports, or videos from where McClellan gained the information. Or two, for reasons that are unknown, McClellan made up the story. It seems unlikely that such a specific story would be made up, leaving the defense to conclude that McClellan has additional Ricky Davis letters, reports, or videos, but has not turned it over to the defense. McClellan has not explained to this court nor anyone else from where McClellan claims he learned his information about the batteries, nor did McClellan back up his story about the batteries with an exhibit attached to the file. Also, note in the email that McClellan requested Attorney Baldwin file something which Baldwin did not have. McClellan then cast aspersions about the filing. McClellan's history or holding on the exculpatory evidence until being forced to or called out by the defense. Unfortunately, as has been the historical pattern of the prosecution, McClellan has made the decision to hold on to those letters until called out by the defense, much like he made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana courts of appeal have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns. Pruitt at 397. 1. Steve Mullins claims that the Brad Holder and Patrick Westfall and other crucial early interviews between February 14, 2017 and February 20, 2017 were recorded over was not relayed to the defense until January 30, 2024, in spite of the defense asking for the evidence since August 10, 2023. As anyone in the criminal justice system knows, often the most important interviews are those interviews closest to the time to the crime. Brad Holder and Westfall were on law enforcement's radar screen as suspects very early on in the case. In fact, that is evident from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted at evidence during July 30th through August 1st, 2024 hearings. Because of law enforcement's very early interest in Brad Holder and Patrick Westfall, each were quickly found and then quickly interviewed February 17, 2017, within 3 days of the murders. On August 10, 2023, the defense first unveiled the prosecution that the defense believed the state's own evidence supported that Holder and Westfall were involved in the murders. From a single 2-page document found among hundreds of thousands of documents, the defense found the evidence that the law enforcement had interviewed Holder and Westfall on February 17, 2017, and that both interviews were memorialized through audio-video tape. It was after the August 10, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. When McClellan and Mullen failed to turn over those interviews or explain what happened to those interviews, the defense called out the prosecution in the Franks memo filed on September 18, 2023. Footnote 66 on page 56 of the memorandum details the prosecution had failed to turn over the Holder and Westfall interviews that the defense had been seeking. Even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over Holder and Westfall interviews, the prosecution still refused to answer the very simple question posed by the defense of where is the Holder and Westfall videos? Please turn them over. The defense heard crickets. Instead of immediately alerting the defense August 10, 2023 that those videos had been taped over, McClellan and Mullins said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents on certain hard drives that it had turned over to the defense. In the fine print on page 5 of this document, the defense finally learned What McClellan and Mullen were claiming happened to those crucial interviews. They were recorded over, along with all the crucial interviews between 2/14 and 2/20 of 2017. Neither McClellan nor Mullen called the defense and said, "We should have told you this when you first got the case," or at least back in August 2023. But those interviews you have been seeking for the last 5 months were taped over in 2017. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullen and McClellan's claim that the crucial video was taped over, as such information was sandwiched between other minutiae contained in the document. This should also be overlooked if, in fact, those crucial videotaped interviews were actually taped over. That would be colossal news that Mullen and McClellan should have not forgotten. Losing such evidence would be the talk of the Unified Command due to the serious nature and potential serious consequence of losing such important evidence. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of a man in charge of the evidence, Steve Mullen, nor the minds of those Unified Command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullen and McClellan should have immediately said to themselves, "Oh no, those interviews were erased back in 2017. I need to immediately tell the defense. I should have told them that when they got in the case, but I will do it now." It is inexplicable that Mullen and McClellan would not have remembered in August 2023, when the defense first requested those interviews, that the interviews had purportedly been recorded over. Yet neither McClellan nor Mullen told the defense of this earth-shattering type of news that Mullen had known for 6 years at that time. To make matters worse for Mullen and McClellan, when the defense finally learned of the so-called recorded-over interviews, the defense asked if there were some documentation memorializing what exactly happened to those interviews, how it happened, and that crucial evidence had been recorded over. Surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had been yet tendered to the defense. Some point in time, the defense finally received such a report. It was drafted by Steve Mullen. Inexplicably, it was undated. Therefore, no one knows if the report was drafted in 2017 or sometime in 2024 or anywhere in between. That document was entered as an exhibit of March 18, 2024, motion to dismiss. This undated document is not normal, nor the normal way that the law enforcement and prosecution operate. The question must be asked, therefore, why did Mullen and McClellan not immediately alert the defense that Holder and Westfall and many other interviews were recorded over when the defense first asked McClellan and Mullen for those interviews in August 2023? And why did Mullen and McClellan not turn over the undated document purportedly explaining how the interviews were recorded over until after the defense requested that document? The defense has not seen anything other than undated documents and the words of McClellan and Mullen that support the interviews were actually recorded over. This is not normal and is very troubling. Neither McClellan nor Mullen nor anyone else in Unified Command has ever explained to the court nor anyone else why they did not immediately alert the defense that crucial evidence sought by the defense has been purportedly recorded over. Neither McClellan nor Mullen or anyone else has ever explained to this court nor anyone else why it took 5 months before providing a document detailed the claim of Mullen of what happened to those interviews. Those are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were recorded over. This is not normal. Here's a side note. 2. For over 4 months, McClellan held on to exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned initially that McClellan may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led him to believe that Holder and Fields and perhaps others were involved in the murders. Back to the document. As this court knows, the Franks memo, including documentation provided to the court in that memo. On May 1st, 2023, McClellan received through the United States Postal Service a certified mailing from attorney Paul Baranda that detailed why his client Todd Click was concerned that McClellan did not have all the information necessary before making an arrest. This certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to the defense from likes of Elvis Fields, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you were a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense lawyers by phone to alert them that the prosecutor had received this information that clearly was exculpatory. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that they, the defense, would soon be learning of that certified mailing. In the August 10, 2023 deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report where the prosecution had to know that Click was a member of that investigation trio of law enforcement along with Kevin Murphy and Greg Ferenczi. McClellan had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, through his lawyer, had mailed a letter, much like Ricky Davis, to the prosecutor with exculpatory evidence. McClellan's failure to immediately turn over the exculpatory evidence has never been explained to this court or anyone else. Why did it take McClellan over 4 months to turn over this evidence? Similarly, it took McClellan approximately 4 months to turn over the Ricky Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. 3. Why in September 6, 2023 email to the defense did McClellan claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact law enforcement had known the identity of the Purdue professor since mid-August 2023? If not before then, did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming it may not be able to learn his identity? Back to the document. In yet another example of what appears to be an attempt to conceal exculpatory evidence, McClellan has yet to explain to this court or anyone else why he sent an email to the defense on September 6, 2023, claiming that he and law enforcement did not know the identity of the Purdue professor, and more curiously, that they may never learn the Purdue professor's identity. The Franks memo was filed on September 18, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor, Jerry Turco. Only 13 days earlier, it was thought that his identity may never be known. According to McClellan, but after the Franks memo, where the missing professor was discussed, he found almost immediately. Let there be no doubt the Purdue professor's report and even his October 19, 2023 interview revealed the murders may have left behind sticks in the form of runes consistent with the defense theory. This is called exculpatory evidence. And we have another footnote. 4. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said the argument that these markings constitute an inscription inspired by Norse runes or modern recreation thereof is quite plausible. These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not be surprising if Holman or McClellan would want the defense to not have this access to this report, as the report supported the defense theory that Norse paganists left the sticks behind in the form of runes. In his September 19, 2023 interview with Holman, Turco commented, I think the idea that someone is trying to kind of replicate, early Germanic, rune script, that seems, I think, a given. Both the report and Turco's own words in his interview stray far from the Holman represented in August 10, 2023. deposition as to what the Purdue professor's words were. Holman claimed under oath that the Purdue professor had stated that the sticks were not Odinism or any type of cult worshiping or any type of a group that would have conducted the crime. Holman simply put, misrepresented under oath the findings of the Purdue professor, who never said that the sticks were not present or representative of Odinism. Rather, the words the professor used was that the possibility was quite plausible, and it was given. Holman's representation under oath is very troubling, and that he has never explained himself to the court or anyone else. The defense believes that evidence supports that McClellan did not want the defense to learn the name of the Purdue professor, and the September 6, 2023 email that he, McClellan, has yet to explain. Turco's report and interview supported the defense theory that Odinist, Norse, paganist were the murders that left behind ruins of the crime scene. After Holman's September 19, 2023 interview of Turco, Holman prepared a report dated, because reports are normally dated, September 22, 2023, in which Holman admitted that he had known of the likely identity of Purdue professor since mid-August 2023. If this is the case, again, why did McClellan not disclose this information to the defense instead of claiming that the defense on September 6, 2023, that the identity was unknown and may never be known? Again, McClellan has never answered the question to this court or anyone else. To the defense, it appears as yet another example of McClellan's attempts to conceal exculpatory evidence from the defense, much like the Ricky Davis letters, and it is not normal. Here's another footnote or side note. 4. Why did McClellan fail to turn over the faked crime scene photo found on Holder's Facebook page even to this day? And why did Trooper Roland Purdy twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook page before the murders, only to then change his story on August 1st, 2024 at the hearing on third-party suspect evidence? Back to the document. As has been noted in the Franks memo at various times, the defense found among the massive amounts of evidence a report from Trooper Ryan Winters detailing evidence that suspects Brad Holder had an image on his social media page that depicted two girls mimicking the very crime scene that law enforcement found on February 14, 2017. This image depicted two young girls lying on the forest floor with sticks, branches on them, with one of the girls' arms posed almost identically to that of Liberty German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdy. Why would Brad Holder, an early suspect, have such an eerily similar image on his Facebook page? Unfortunately, the prosecution failed to produce the exculpatory piece of evidence. The defense had to drive to Georgia to obtain the image from the very man, Ryan Boucher, who had located the image on Brad Holder's social media pages. Trooper Purdy, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he, Purdy, did not find the image compelling because it had been on Holder's Facebook page for a few years. On July 30th, 2024, Purdy once again confirmed under oath that this is eerily similar faked crime scene was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his two previous sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page. Additionally, Trooper Winters claimed that in his deposition that the Indiana State Police, ISP, could not locate the fake crime scene image that at one time was in the possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. This is not normal. It is also not normal for a seasoned state trooper like Roland Purdy to retract prior sworn statements during hearing in which he mimicked the crime scene image was a central piece of the defense's argument to allow third-party suspect evidence at trial. 5. Videotape of Brad Holder and Westfall in pagan ritual in Fort Wayne. The defense was fortunate enough to locate among hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12, 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. In the video, Brad Holder was tape recording various people in ceremony, periodically yelling out things such as "Hail Thor" at the very end of the video. Brad Holder tape recorded Patrick Westfall standing next to the tree and using his hand to seemingly mark something in the tree. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree and one of the victim's blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution to turn over evidence of an exculpatory nature to the prosecution has in its possession. Normally, the prosecution turns over the evidence immediately without any need to request it. This was yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until forced to provide it to the defense. Complaints from the defense is not normal. Prosecutors claiming they can't locate a key exculpatory witness's identity, a witness, mind you, that purportedly altered the way that the case was investigated, is not normal. Later, learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming that he may never learn of the witness's identity is not normal. The prosecution having no explanation for not providing exculpatory evidence to the defense is not normal. Having no explanation why a report that attempted to explain why key evidence is forever lost was not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims cannot be located is not normal. Finally, having a prosecutor claim in the email that he provided all the Ricky Davis letters to the defense before trial, when just 14 days later he forced to admit that the McClellan represented as such truth in his email was in fact not true, that is not normal. Nor is it normal that one of the letters can't even be located and that the prosecution has no explanation for this missing Ricky Davis letter. It does not matter whether the contents of the letter can be questioned as unreliable. That is not the prosecutor's job to determine. The prosecutor only determination is to turn that evidence over to the defense. The defense should have the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has a constitutional right to possess all exculpatory evidence and then determine how to proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact is that the prosecution had in its possession letters in which a key suspect, Kegan Klein, purportedly confessed to the crimes and provided details that only the killer might know. And that information should have been provided to the defense. Because of the prosecution's failure to produce those letters, and because the prosecution has a history and pattern of not turning over exculpatory evidence, Richard Allen deserves another trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Ricky Davis letters, why he misrepresented his position of those letters to defense counsel in his February 13, 2025 email, as well as to explain the other examples of failing to turn over exculpatory evidence as recited herein, which show a pattern of such conduct. The defense seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in renewed motion for new trial based upon newly discovered evidence, and also, 2, in order to use the state's Indiana's answers to the questions as a record that can be utilized by the appellate lawyers. Should this court deny Allen his request for a new trial? Lastly, Allen asked this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanctioned the defense is seeking is ordering a new trial. I swear and affirm that the statements contained in this memorandum are true and accurate to the best of my knowledge. Andrew J. Baldwin. Okay, that was a long one. Let's do a quick recap because I know you guys are probably ready to fall asleep about this point. Get another cup of coffee. Here we go. So, first of all, I want to go back and say that the defense is incorrect. Literally, we knew about the girls' throats being cut years and years ago. That's not information that was new or that only a killer would know. Ricky Davis could have picked that up from Kegan, from anyone who was feeding him information. Okay, so basically I'm not going to do much of a recap because it seems very confusing that Odinism is back in this memorandum as if it's a thing, and how does that coincide with Ricky Davis's letter saying that it was Ron Logan, Kegan Kline, and possibly Richard Allen as a third person or some other third person? Clearly, the defense is trying to establish that they believe the prosecution has not been forthcoming with information that's exculpatory. However, we've heard time and time again this question answered, showing that the information they are interested in was not exculpatory. So thank you guys for listening in. I hope that you were able to watch the whole video. And again, if you weren't and you just skipped to the bottom of this for the recap, can you please just go back, turn it on and go do dishes, or turn it on while you're driving and listen. It'll help the algorithm for sure. And this was a lot of work I put into here. I've been sitting here for 3 hours producing this video. So I appreciate your help in that. Thanks. Leave me a comment. I cannot wait to hear the comments on this one. And I'm sure that there will be a response from Prosecutor McClellan. We'll see what he has to say. We'll see you next time on Deb's True Crime Notebook.